For a second, I want to bring in Emily Compagno. She's an attorney, but she's also a former NFL cheerleader. Emily, get me off the ledge. Is this crazy or is this stuff airtight?
Hi, Ashley. Thanks for having me on. I would like to explain for viewers what's going on here legally. Now, this cheerleader is alleging gender discrimination, right, under Title VII of the Civil Rights Act. And then we also have the social media policy that falls under the NLRA and basically federal speech laws. So for viewers, I want them to understand that the analysis will be whether the Saints have a compelling business justification for treating the cheerleaders differently. And the largest difference is the unionization, and that it's not about whether they're athletes or cheerleaders, but the designation of independent contractors or potentially seasonal for unionized employees. Now that's really huge, but that's still, the Saints still need to provide that compelling business justification.
So I'm sorry, you're going really quickly. You're going really quickly, and you're way smarter than me. So you got us go to. So you're saying that the fact that the players are unionized and the cheerleaders, who are also athletes, are not unionized, gives them cover for this?
No, it means that gives the Saints broader latitude over the cheerleaders rather than the athletes for their designation. And it means that will be part of the analysis that the EEOC will conduct and in their investigation as to whether they were treated fairly and lawfully. It will go into the analysis of that designation. So if someone is an independent contractor or a seasonal employee, then that gives broader latitude for in comparison to a unionized employee. And if the compelling business justification is safety, and that's accepted or if it's profit interference, if it's any kind of compelling business justification the Saints provide, that will be part of the EEOC's analysis. So my job here is just to provide those aspects that the EEOC will look at. I'm not saying that that's what everything will hang the hook on, but that's one and a kind of a material. It's a material factor.
Yeah,
and
I would have loved to see these people mess with you when you were an LA Raider. Seriously, the way you're talking, it's just like, man, I'd like to see you defend, Bailey Davis. In fact, before you go on, this is Bailey Davis on the Today Show, defending herself and essentially characterizing how she feels in her employment, or was in that employment, and how she feels all of them are in that role. Take a look.
We have always been told, you're replaceable. There's hundreds of girls that would do this for free. So that's kind of why, any little thing, we just kind of kept our mouth shut because we wanted to be professional cheerleaders. It's not fair that we've worked our whole lives to do this professional job as well as the players have, and we're stifled by these rules.
So let me ask you this, Emily. Is she trying to, in essence, show that the NFL and maybe the Saints as well have violated Title VII of the Civil Rights Act of '64? And if that's the case, what does that mean?
Yes, she is alleging in her complaint that she is being discriminated against because of her gender. And it means that in this investigation the EEOC will undertake, they might find either cause or no cause, and then that could result in lawsuits later. I also want to draw viewers' attention to that social media policy because I think it goes against a lot of our intuition. The National Labor Relations Board has held that it is against federal law for employers to have their employees hide where they work. They have also held that it's against the law for employers to require that their employees do not use the logo. And they've also held that words like inappropriate or unprofessional are overbroad. And ultimately, at its heart, they're protecting concerted speech. They're protecting speech that these employees can air grievances against their employers. And these are things that we see in a profit sense, right? We think, well, only the NFL should be able to use the logo. And that dovetails in with all of the allegations she makes in her complaint, that she couldn't say she was a Saints cheerleader, etc. But I just want everyone to understand that it's against the law for that free speech workers' rights movement. So that, to me, is an interesting twist to this case that might shed some light.
Let me get a second voice in here. Troy Slayton is a defense attorney. You've looked over the docs. You've looked over the case. Do you think she has a case? Do you think she can win it?
I think that the NFL and the Saints actually have a leg up here. And it's because even though these policies may seem from a time past, this woman would have to show that it was put in place specifically to discriminate against women or minorities. And here,
well, I don't see any male cheerleaders, Troy. All I can say is that when a woman is told you have to avert your eyes, and I don't see any women players or coaches, avert your eyes means, ladies, avert your eyes, the man's coming through. But you know what? It's going to be up to the parties and the judge. I got to cut it there. Troy, thank you. My thanks to Ahiza Garcia as well and Emily Compagno.